Hey, good afternoon, everyone, and welcome to our June edition of In the Boardroom with attorney Andy Phillips and Attolles Law, brought to you by the Wisconsin Counties Association. And today we're going to talk to you about ethics and conflicts of interest. And of course, by we, I mean Andy Phillips. And we'll turn it over to Andy in just a moment. But first, I just want to give you a couple of reminders, as always. If you have any questions or comments during the webinar, please feel free to enter them into the chat or the Q&A feature of Zoom. It should be found in the lower portion of your Zoom screen. Click on one of those, and I will be monitoring the chat in the Q&A along with Andy throughout the hour-long session today. And just note that if you put in, it's always our goal to try to get through the full presentation within the 1 hour that we have allotted. So if we don't get to your question right away, do not fret. We will get to it once Andy has completed the presentation. Otherwise, this webinar is being recorded. So if you have to leave partway through or wish to watch it later on, you will find that along with the PowerPoint presentation on the WCA website, www.wicounties.org. There is a place called on the upper right of the webinar screen or our website screen called WCA Webinars. Click on that, and that will get you right to the recording and the presentation, which we usually have posted pretty shortly after the webinar is completed. So today we have a great topic that we are going to be discussing. This is a topic that we have received a number of questions about, I would say, in the last few weeks. And the analysis on all of those questions is always interesting, I think. And so I'm excited that we are going to be addressing ethics and conflict of interest today. So with no further ado, Andy, I'm going to turn it over to you.
Thank you, Sarah. And for those of you who couldn't figure it out, Sarah and I are actually in the same room on opposite ends of a long conference table. And we have to be on mute with one another because it's an odd echo. I can hear her talking, and then a second later I hear through my AirPods here. And so we're going to try not to talk over one another today to make this simple. As Sarah mentioned, this is a topic that's actually garnered quite a bit of interest recently. Not sure why, and I think it's a topic that frankly garners quite a bit of interest all the time, but it seems in the last couple of months, we've gotten a lot of questions about ethical issues, conflict of interest issues. And so we thought it a good time to revisit this topic, which I think we last talked about this about a year and a half ago or thereabouts at an In the Boardroom session. So it's always good to have a refresher on ethics and conflicts of interest. And as much as I want to talk about what the rules are surrounding 19.59's categories of prohibition and 946.13's categories of conflicts of interest, I also want to talk about what ethics and conflicts of interest are not. And the reason I want to do that is that I think that there is a misconception that's out there about how if somebody is engaging in misconduct or poor conduct, that somehow rises to the level of an ethics issue. And it typically does not. Just because somebody's mean, just because somebody is not following the appropriate rules that the board has established, that doesn't mean that they're unethical. It just means they're misbehaving. We deal with that issue separate and apart and completely distinct from the way that we deal with ethics issues or conflicts of interest issues. And so I want to make clear what we're talking about when you hear me or Sarah or somebody at WCA or other lawyers talking about ethics issues, make clear what those are, and conflict of interest issues, as opposed to the bad behavior type issues. The other thing I want to address today is this whole doctrine of incompatibility. And some of you may be aware that that's received some attention here in the last couple of months, given what happened within a particular county and a county constitutional officer. It's a really obscure area of the law because while statutes sometimes define incompatibility, in other words, you can't hold position A and at the same time hold position B, that there is this common law doctrine that's out there. Common law simply means it's judge made. In other words, it's a doctrine that exists as part of the law without being written into the Constitution or statutes. There's a common law doctrine on incompatibility where there's essentially recognition that holding two positions at the same time presents too many opportunities for conflict of interest and problems. So therefore, we are going to say that you cannot hold those two positions simultaneously. I want to talk about that a little bit today as well. As Sarah mentioned, please feel free to use Q&A or chat to ask your questions. We'll get to them as we can. We've already got one Q&A out there, Sarah. So even before I started talking, we had people asking questions, which means this is obviously a topic of interest for everybody. So let's talk about ethics and conflicts of interest here. I want to start with this proposition here that from a legal standpoint, of course, I'm a lawyer, so I deal with the legal issues. Legal issues means that in the worst case scenario, you're going to court and you're having a court or a judge decide exactly what the implications are for what is alleged to be unethical conduct. But more importantly, is the reputational interest that is in jeopardy as a result of some sort of ethics or conflicts of interest issue. And I'm reminded, I found a couple of quotes here, and I'm reminded how important this is because I think these quotes really do a good job of outlining this. Warren Buffett has said it takes 20 years to build a reputation and 5 minutes to ruin it. We've got Henry David Thoreau. There is no odor so bad as that which arises from goodness tainted. So why do we have these there? Why did I think that these were good? Is that even though something may pass muster under the local ethics code in 19.59 of the statutes, that doesn't mean that your reputation isn't going to be impacted. And so what we want to provide during this in the boardroom is a foundational understanding of ethics issues. And then we're even going to provide what we call the 6-part smell test to help you avoid these ethics issues so that you are very well equipped that when these situations arise, that you take appropriate steps to either shield yourself from that tainting that Henry David Thoreau was talking about of unethical conduct, and you put yourself in a good position, not only legally, but also practically, so that the public has full faith in what you are doing as an elected official or an appointed county official. So let's start with a very broad proposition. Who's covered? All right, we've got a local ethics code, or it's an ethics code for local government officials in 19.59 of the statutes. Who's covered? Well, counties are covered. No doubt about it. There's other subunits of government that are covered, but counties are covered definitionally. To whom does this apply? Which people, which local government officials are subject to the ethics code in 19.59 of the statutes? We've got local public officials. That's a defined term in the statute. Elective officers of local government, your county administrator or administrative coordinator, an appointive office in which the employee is appointed for a specific term, an appointive office filled by the head of the local government, and then we've got things dealing with the local exposition board. But here again is a situation where I see some misconception out there from time to time. I think people think wrongfully at times that all employees of a county are covered under 19.59 in the ethics code, and that's just not true. You have to be a local public official to be covered under 19.59 of the statutes. As we'll learn in a little bit, that doesn't mean that we can't have our own local ethics code as a county that does apply to employees, but from a state law perspective, employees are not covered under the 19.59 prohibitions. There are basically 5 categories of prohibited conduct that we're going to talk about. And the first is ban on the use of your position to get anything of financial gain for you, an immediate family member, or an organization with which you're associated. A ban on offering or giving, and also a ban on receiving as an official anything of value if it reasonably could influence your vote, official action, or judgment. There's a ban on directly or by means of an agent making a promise to vote a certain way or take certain action or refrain from taking certain action in exchange for a political contribution. There's a ban on taking any action substantially affecting a matter in which you as an official, a member of your immediate family, or an organization with which you're associated has a substantial financial interest. And then there's a ban on using your office in a way that produces or assists in the production of a substantial benefit, direct or indirect, for you, family member, or an organization with which you're associated. So those are the 5 basic categories of prohibited conduct. Remember, I said early on that there is a distinction between an ethics issue and a conduct issue. When we're talking about ethics issues, frankly, when we're talking about conflict of interest issues under state law, under state statute, we are typically dealing with a financial issue. In other words, there is some money involved in the process such that the improper use or way of handling that particular money issue would potentially lead to an ethics issue. A conduct issue, of course, isn't always tied to money. Most times it's not tied to money. And so I always encourage folks to think about our ethics and conflicts of interest under state statute, state law. We're dealing with financial stuff. If we're dealing with conduct stuff, that's a matter separate and apart from the financial issues, and we're going to deal with that under our board rules. So let's look at the first category. And I'm going to spend a little bit of time here on this first category because in talking about ethics issues, it can be challenging because I think everybody understands that something just kind of makes sense. That when we say that, oh, well, yeah, you can't use your public position to get financial gain or anything of substantial value for you, your immediate family, or an organization with which you are associated. That makes perfect sense. But then let's dive a little deeper here and look at the terminology that's contained within this category of prohibited conduct, and then it permeates the other four categories as well. Well, what is financial gain and what is anything of substantial value? We know that the Ethics Commission, through its opinion process, has come out with guidance suggesting that anything more than $25 is going to be considered to be having substantial value. Does that mean that something under $25 doesn't have substantial value? Does that mean anything over $25 automatically is considered to be of substantial value? And the answer is no, it's not automatic. It's not in statute. And this highlights some of the difficulties that we have in drafting ethics codes and using certain terminology that, again, I think everybody has an understanding of what it means, but it's very difficult to put into words. And so what I'm going to tell you is that on the one end of the spectrum, we've got our copier repair company that comes to the county administration building to repair copiers, and in the process of repairing those copiers, hands a county board member a squish ball with the logo of the repair company on it. Does anybody think that that is something of substantial value? No. On the other hand, if copy repair company hands county board supervisor 2 tickets to the Super Bowl, does anybody think that's not something of substantial value? Absolutely not. But there is a lot of gray in between the squish ball and the Super Bowl tickets. And the challenge that we have, all of us have, is making sure that when we err in that gray area, that we err on the side of caution. That if we have a question in our mind about whether anything has substantial value, that we go and seek advice to make sure that we are not crossing the line into what would be prohibited conduct. So that's our first challenge, is defining financial gain, anything of substantial value. The second challenge we have is the application of this prohibition to the different classes of persons. Well, of course, we've got the individual, the official, him or herself. Yeah, no doubt about that. That's easy. But then we get into this definition of immediate family. And this is where the statutes define the term immediate family differently than I think all of us would consider immediate family is to be defined in common communication. Immediate family doesn't mean brother, doesn't mean sister, doesn't mean what we would think of as immediate family. It's defined as an individual spouse and a relative by marriage, lineal descent, or adoption who receives directly or indirectly more than one half of his or her support from the individual, or from whom the individual receives more than one half of his or her support. And so brother relationship could be immediate family if brother lives with, for example, county board supervisor and receives support from county board supervisor, or vice versa. But brother in and of itself is not a relationship that is going to be swept into the definition of this category of prohibited conduct. And for that matter, any other category of prohibited conduct under 19.59, because that brother relationship is not going to be the relationship immediately recognized as immediate family. And then finally, we have an organization with which the individual is associated. This is a tough one because what does it mean to be associated with an organization? Does that mean part owner? Does that mean employee? Does that mean member on the board of directors? Does that mean a volunteer that assists the association from time to time? And that's not defined precisely within the statutes. And I think that requires a case by case evaluation of the relationship between the individual and the association or organization that is receiving some sort of benefit as a result of what that organization does in terms of business with the county. Now, I see a lot of things arise, a lot of times I see this arise in the context of a nonprofit association that is receiving some sort of financial contract from the county, and you might have a county board member that volunteers for that organization. For example, Meals on Wheels delivers some Meals on Wheels and things like that. Is that the type of relationship that is going to cause concern under 19.59? Maybe. And I'm going to give you the complete lawyer answer here and say it depends. And it's awfully easy for me to say this, but the reason that I'm saying this is that it depends on a whole number of circumstances that exist that you evaluate to determine, is this the type of organization and relationship between official and organization that is going to trigger some problems under 19.59. But I'm also going to tell you to remember what Warren Buffett said, is that you can ruin a reputation in 30 seconds. And so understanding that just because you don't have a technical violation of 19.59 doesn't mean you have no ethics issue. You might not legally have an ethics problem, but in the court of public opinion, you might have a concern. And so I think our goal ought to be to avoid issues under the law and also to avoid issues in the court of public opinion. Okay, I've got a couple of questions here, and I'm going to pause for a moment because I think these are actually good questions. Catherine asks, a board member has a brother and sister-in-law employed by the county, both directors. Does the conflict of interest extend beyond financial gain? Example, departmental gain. Well, again, it's anything of substantial value. And so it's defining what anything of substantial value means. All right. What I will tell you, though, is that if we look at the definition of organization, when we get to the third bullet point here, an organization with which the individual is associated, excluded from the definition of organization is another municipal government or another governmental agency. And so just because somebody sits on a town board and also sits on the county board, and just because the town may receive some sort of benefit as a result of a contract with the county, does not mean that that particular supervisor, who's a town board member and a county board member, has a conflict of interest or ethics issue. That's not true, because that town is not an organization considered to be an organization with which the individual is associated. So again, it's tough to define a lot of this terminology. So my advice is to immediately consult with corporation counsel to raise the question, because corporation counsel is the expert on the application of the ethics code. Stacy noted that the value of the Super Bowl tickets may depend on who's playing in the Super Bowl. I think that's right. If it's the Packers, it's obviously an incredibly valuable ticket, and some other teams probably not so much. For example, like the Bears or something like that. Catherine notes that their policies in their county define immediate family member as, and then there's a list, brother, sister, parents, so on. That's fine. That's in your local code, and your local code can expand on the definition that we have in state law. So I want to make clear that what I'm talking about right now are the prohibited conduct categories in 19.59 of the statutes. Your own ethics code might have different definitions and different prohibitions. Again, talk to your corporation counsel about how you handle those sorts of things. I think we had one in Q&A as well, Sarah, and let me just take a look at this quick. So we've got an issue where we have a county board member essentially lobbying or being inserting themselves into a discussion of whether a particular school district ought to have a resource officer. We have a spouse that's employed in the county within a department. And so we have this overlap, if you will, where we really don't know which hat county board member is wearing at any particular time, because they seem to be advocating in the best interests of the school one day and the county another day. There's no prohibition on doing that. I think it probably smells a bit And I think that, again, in the court of public opinion, it doesn't look good. And so we ought to make clear which hat this particular board member is going to be wearing at any particular time. And if it's a situation where there is some sort of interest beyond the normal public policy interest that this supervisor seems to be advocating for, that we identify that interest and make sure it's known. So when we talk about the reputational interest at stake as a result of ethics issues, part of it is transparency. Part of it is just letting the public know, hey, this is what's going on. This is the relationship I have. I am not going to recuse myself because I think that's a really important issue for the county. I'm not going to abstain from voting because the law allows me to take official action on this topic, but I want everybody to know that when we're dealing with this issue, my spouse is employed at the school district or whatever the relationship is. That level of transparency allows the public to understand that you recognize some potential issue that could be there, even though it's not a violation of the law. And as well, it gives your fellow board members the opportunity to assess whether they ought to give particular weight to your particular opinion. And so I always err on the side of disclosing situations like that. All right, let's talk about the second category of prohibited conduct. A ban on offering or giving, and if you're a public official, accepting, receiving, directly or indirectly anything of substantial value, if it could reasonably be expected to influence your vote, official action or judgment, or reasonably be considered as a reward for any action or inaction on the part of the local official. And so this is kind of a pay for play category of prohibited conduct. I'm going to give you something of substantial value in exchange. I expect you to either vote for my measure or vote it down or whatever the case may be, pay to play. Here's the problem with this category of prohibited conduct. The same as we had in the first category of prohibited conduct is putting a finer point on the definitions within this particular category. It's a ban on offering or giving directly or indirectly. So that's an incredibly broad prohibition. And you can't use some sort of surrogate to deliver some sort of substantial value to the public official and say, well, I didn't directly give them the money. No, it's through the surrogate. And that's why we capture it with indirectly used within this statute. Then we also have the use of the term anything of substantial value. Again, I think it depends on the circumstances as to what has or doesn't have substantial value. All right. So we have this second category of prohibited conduct. The third category of prohibited conduct, and this is really dealing with campaign finance, is that directly or by means of an agent, so again, you can't go through a surrogate, give, offer, promise to withhold, vote or influence, or refrain from taking official action or take official action in exchange for a political contribution. All right. I think everybody recognizes that this category of prohibited conduct is universally a good idea. No doubt about it, is that we do not want pay to play in exchange for campaign donations. We do not want that. I'm just going to say that there are a whole host of other rules that relate to campaign contributions that we're not touching on here. But again, at least as it relates to the ethics code for local government officials in 19.59, we have this third category of prohibited conduct that speaks directly to that pay to play system within the context of political contributions. The fourth category of prohibited conduct, ban on taking any official action substantially affecting a matter in which you, a member of your immediate family, or an organization with which you're associated has a substantial financial interest. Here we see another phrase or term that's utilized that doesn't have precise definition. What is a substantial financial interest? Is that going to be defined the same as anything of substantial value? So $25 is the threshold, or does substantial financial interest mean something else? I think it probably means something else. And unfortunately for everybody, we don't have a bright line rule to say, well, X amount, it means you have a substantial financial interest, but Y amount means you don't. We don't have the X and the Y. And so it can be, again, very challenging to apply this prohibition depending upon the circumstances. There is an interpretive exception to this fourth category. All right. So on this fourth category, again, it's official action substantially affecting you or your family or an organization with you're associated because you have a substantial financial interest. There's an exception in that you can, it's called the class exception. You can take this action even if there is a substantial financial interest at play, as long as the action you are taking is going to impact a whole lot of other people other than just you, your immediate family, or an organization with which you're associated. All right. So again, this is what we call the class exception to that particular rule. So, for example, if it is under consideration at the county board to amend your zoning ordinance to change the zoning classification of a group of properties from ag to residential, because those properties are going to be developed. If you own one of those properties, you're going to be significantly impacted by that decision. And that fourth category of prohibited conduct is going to say you've got to recuse yourself and not be involved whatsoever in the official action at the county board level on that particular decision. But if we're dealing with 200 properties and you happen to be one of 200, your interest is not going to dwarf the other 199 that are impacted. And so the law would recognize your ability, excuse me, to take action based upon that particular class of impacted properties. But again, and I'm just going to remind everybody of this again, it still may stink to high heaven. And if it's going to stink to high heaven and it's going to look like you're self-dealing, then you need to get out of that situation and make sure the public knows that you're getting out of that situation. Because the headline of the paper is going to be County Supervisor Phillips votes himself a heck of a sweet deal with a development plan by rezoning his property. That's what the headline in the local paper is going to read. It's not going to say Supervisor Phillips participated in the official action because it was determined after thoughtful consideration with Corporation Counsel that Section 19.59 in the fourth category of prohibited conduct were not implicated by that particular decision because of the class exception contained within statute. Number one, that's too many words for a headline. But number two, nobody digs into the details. Everybody wants the soundbite, and the soundbite is that you took action on a matter that you're impacted by. And then finally, we have the fifth category of prohibited conduct: ban on the use of your position in a way that produces or assists in the production of a substantial benefit, direct or indirect, for the official, one or more members of your immediate family, or an organization with which you're associated. This is another situation where we've got terminology that isn't really easy to figure out. Production of a substantial benefit. We've talked about this term: substantial benefit, substantial financial gain, substantial impact. We've talked about this previously, but here we've got substantial benefit, direct or indirect. What is an indirect substantial benefit? That's a really good question. And again, I think it depends on the circumstances. It's just, again, when we look at this, are we using our position in a way that is going to produce benefit for me, my family, or an organization with which I'm associated? If the answer is that, if the answer to that is even maybe, we need to exit ourselves from that situation as quickly as we can. All right, so state statutes, 19.59, they do not prohibit a local official from taking action on salaries, benefits, or reimbursements, or from voting on a county or municipal ordinance. All right, so whenever we have a resolution going before the county board to deal with, for example, the salary schedule within the county, even if your spouse is employed by the county, there is no ban on taking that sort of action on that salary. That's a recognized exception. That being said, again, I'll remind everybody, it may appear to stink to high heaven. So you got to be very careful about what you're going to rely upon in order to take the official action. All right. So let's talk briefly about the enforcement of the ethics code for local government officials. Again, it's 19.59 of the statutes, and there is an enforcement mechanism contained within those statutes. It's a pretty bad penalty if you get yourself in hot water under that local government, that ethics code for local government officials. The forfeiture of not more than $1,000 for each violation. And if you remember, the third category of prohibited conduct related to the pay to play for political contributions, there's an enhancer contained within the statutes. That means if you do that, Not only are you subject to a potential forfeiture, but also you're subject to prosecution as a Class I felony, punishable by a fine not to exceed $10,000 or imprisonment not to exceed 3 years and 6 months. So the consequences of violating the ethics code can be very severe. So we have a get out of jail free card. It's a wonderful, wonderful tool that is available to everybody in county government subject to 19.59's restriction. That means we can go to the Corporation Counsel and request an advisory opinion. If we go to the Corporation Counsel, request an advisory opinion, and then faithfully follow the advice that's provided, we have immunity from prosecution under the Ethics Code for an ethics violation. But there are some very important concepts here. Now, I want to make sure everybody understands. You have to go to Corporation Counsel before the issue arises. You can't go to the Corporation Counsel after the meeting at which you took a particular vote and say, was that okay? You need to get that advice up front, number one. Number two, you need to get that advice in writing. It can't just be verbal advice because we don't want to get into a debate about what was or was not said in the context of Corporation Counsel providing you with that opinion. And then finally, you have to follow precisely what Corporation Counsel says you need to do in order to avoid liability. So again, you have to go to Corporation Counsel before the situation arises. You have to get that advice in writing, and then you have to faithfully follow that advice. If you do those three things, you're going to be immune from liability under the ethics code. So we talked about this earlier too with a couple of questions that we had answered, and that is, well, can we have our own ethics code? And I know several counties have their own ethics code, and I know that there are other counties that are contemplating their own ethics code. Why are they doing this? Well, there are a variety of reasons, but primary motivator from my view is that they want to either enhance the people who are subject to the ethics restrictions and sometimes they want to better define what they consider prohibited conduct to be. And so state statutes allow counties to adopt their own ethics code. In 19.59 sub 1M through 4, you have a provision in statute that recognizes a county's ability to adopt its own ethics code, and then it has certain restrictions, if you will, that have to be contained within that county ethics code. I've been asked the question a few times in my career, can our county ethics code do X, Y, and Z? Can our county ethics code apply to A, B, and C? And it's always a challenging analysis because statute isn't entirely clear exactly what has to be in a county ethics code. And why is that concerning? Well, I don't want to dovetail too far into a conversation about home rule authority for county government or 5903 or 5951, but it gets back to this notion that counties are creatures of the legislature and we have to do what we can within the boundaries that the state legislature has adopted. So if the state legislature hasn't given us authority, specific authority to do a certain thing, there's always a question, do we have inherent or home rule authority to do that sort of thing? Same thing applies here with our county ethics code. Can we have things in our county ethics code that just aren't addressed in 19.59? And I think that's an open question as to whether we can or cannot. So what I like to tell counties is that the more we can stick to those 5 categories of prohibited conduct, and perhaps we want to refine those a bit, the more we can stick to making it apply to counties, employees, and officials, the better off we're going to be, because that's consistent with the framework that's established in 19.59. In the statutes, it says that we can have an economic interest disclosure process. I've seen different counties do this, and there is the ability in statute to say if you do not disclose economic interests, we can pull your name from the ballot. You're not eligible for election. We can direct the treasurer to withhold payment of salaries or expenses if you fail to disclose economic interests. Why do we have economic interest disclosures in the first place? Well, do you remember when I was talking about transparency with the public and with your fellow board members? An economic interest disclosure is promoting transparency. It's letting everybody know where your economic interests lie. And so I think, again, it's up to you as to whether, from a policy perspective, you want to have this in your ethics code. But I think something like this is a good idea because it lets the public know exactly what's going on with their county board in terms of where their interests might lie. It can also provide for administration and civil enforcement of the ordinance through an ethics board. It can prescribe the standards of conduct. It can prescribe penalties, including forfeiture not to exceed $1,000 for any one violation. What I'm going to tell you here, though, is that be very, very careful about drafting your own ethics code. The reason I say that is because I have unfortunately seen ethics codes be used as a sword. In other words, it is a tool that certain people utilize in order to create problems for a particular supervisor or group of supervisors. There is nothing worse in terms of the public perception of a supervisor than to be alleged to have violated an ethics code. So and so is unethical. So and so is self interested. So and so has a conflict of interest. That's pretty serious in terms of allegations. And so I don't want to see ethics codes be used as a sword in that fashion. And so in the counties where I've worked with them on their particular ethics code, I've always been very careful when it comes to administration of that ethics code to have a process to initially evaluate complaints that a member files against a board supervisor or other county official or employee. Through that vetting process, we can determine whether or not that particular issue has merit, that particular complaint has merit. The other thing I will say is that oftentimes corporation counsel gets put in a tough spot. Corporation counsel may be viewed as picking sides if it's corporation counsel involved in that initial evaluation process. So when drafting your ordinance, if this is the route you decide to go, for that matter, if you already have an ordinance, take a look and see what do we do in terms of administration of our ethics code to make sure that we have an initial vetting process to ensure we don't have people using that ethics code as a sword. All right, so I talked about this earlier too. We have a smell test here that if you answer yes to any of the following 6 questions, you may have an ethics issue, and that means you immediately go to corporation counsel and have a discussion about those issues. I don't need to read these to you today, but they're all here. As Sarah mentioned, the recording and the slide deck for this particular presentation are going to be available at wicounties.org this afternoon. Go to the website, print off, if you don't print off the whole presentation, print off these slides and use the smell test liberally and often, because this is going to guide you. All right. Nobody expects you to be an expert in 19.59 of the statutes, or for that matter, your local ethics code. But what everybody does expect is that you are going to have enough foundational information about ethics and conflict of interest to understand when those alarm bells go off, when something smells funny, that you're going to go seek advice from the professionals who are the experts in this area. And so again, if you go through these 6 questions and if the answer to any of them is yes, immediately go and have a conversation with corporation counsel. All right, now we're going to switch gears a little bit and talk about this common law doctrine of incompatibility or compatibility. All right, it's a long-standing doctrine, and as I mentioned at the outset, it exists independent of any statute, ordinance, constitution, or other, other regulation. It essentially is judicially recognized that there are certain positions within government that a single person simultaneously holding those 2 positions is impossible. You can't do it. And so under the doctrine of incompatibility, a court is going to say you cannot hold both of those positions. All right. If we look at McQuillan's, which is the treatise around the country on municipal corporations, and this treatise has been around for a long time, and it applies to states other than Wisconsin in terms of its analysis of the legal issues impacting municipal entities, of which a county is a municipal entity. In McQuillan's, that treatise recognizes that courts all over the country, common law doctrine, have recognized that If there is incompatibility where we have simultaneously holding two positions with one person, that the mere acceptance of the second incompatible office per se terminates the first office as effectively as a resignation. So what we're saying here is that if the two positions are incompatible, a court has the authority to say they're incompatible. And as soon as a court does that, it's as though the person vacated the first position they held when they took the second position. All right. So again, pretty significant consequences as it relates to compatibility that we need to be aware of. We have cases in Wisconsin that define incompatibility. Again, it extends to positions of public employment as well as public offices. We don't have the ability, unlike the 19.59 categories of prohibited conduct, where we might have the ability to recuse ourselves or abstain from voting in order to avoid a 19.59 issue. We do not have that luxury when it comes to compatibility. We don't have the ability to abstain from voting or recusing ourselves and get out of an incompatibility question. Now, you're probably wondering, okay, well, is there a list out there of positions that have found to be incompatible? There is a list, but the list isn't complete because it's the Attorney General weighing in on compatibility and then issuing an opinion, formal or informal, on compatibility. And the Attorney General's opinion is just that, it's an opinion. It does not have the force of law. All right. So it would take a court case to make a determination as to whether a particular office is incompatible with another office. All right. So we have to be very careful about the way we evaluate this. That said, there are certain statutes that define compatibility. The most obvious one is 59.10. I don't have off the top of my head. I think it's sub 4 of this, or maybe it's sub 7. Either way, 59.10 says that a county employee is ineligible for the office of county supervisor. That means that a county employee can't even take out papers to run for county supervisor. The reverse isn't necessarily always going to be true. A county supervisor is eligible to be employed by the county, but as soon as they accept that position of employment, they have to give up their county supervisor seat. But I think there are all sorts of ethics issues that arise even before they take that position. After all, there's going to be an application process, an interview process. And how does it look if we have a sitting county board supervisor interviewing for a particular position within county government? I've had that issue arise from time to time over the years that I've been assisting county governments throughout the state. And my position is always, it looks awful to have a sitting county board supervisor being interviewed for a job. Because even though they can say, I'm not trying to influence, I'm not trying to use my office, I'm not trying to do it, it doesn't matter. They're a county board supervisor. And so I always tell counties that even though it's not flat out prohibited by statute, I think it would be wise to have a discussion as to whether we would prohibit a county board supervisor from applying for a position without first resigning his or her seat on the board. All right. As I mentioned, there are attorney general opinions that establish the framework for the analysis. I don't need to read it to you all here, but I think the important part is bolded there toward the end. Incompatibility has been said to exist when there is a built-in right of the holder of one position to interfere with that of the other, as when one is subordinate to or subject to audit or review by the second. Our government, our system of government, relies a great deal on checks and balances built into our system. And whenever we have the same person checking or balancing, we've got a problem. And so that's what we want to avoid. We want to avoid having the same person be the check and the balance. And that's essentially what the Attorney General has said throughout the years. And again, it's not a situation where we could have a particular person absent themselves or recuse or abstain, whatever. They don't have the ability to get around it. The two positions exist independent of one another for a reason, and they cannot be held by the same person at the same time. That's what the Attorney General and our courts have said. Unique issue. I get asked questions surrounding privileged information all the time, and it usually comes in the context of closed sessions. All right. So we know that we go into closed session for good reason. And when we're in closed session, whatever's said in closed session has to stay in closed session. What is, under the open meetings law, the penalty for disclosing information that was discussed in closed session? There is no penalty within the statutes for that. All right. So, do we have the opportunity to better define what happens if we have disclosure of information received in closed session? We do. Now, remember, in our local ethics code, it's not addressed in 19.59 of the statute. So, in our local ethics code, can we define that as giving rise to an ethics issue? Potentially. I suppose you could. And I think there are some counties out there that have. My concern about that is that remember what I said at the outset about ethics and conflicts of interest issues. Those are different than behavior issues. Those are different than misconduct issues. Ethics and conflict of interest deal with money. Behavior misconduct deals with stuff other than money. And so, what I would prefer to see personally, and again, this is subject to your analysis and discussions with your corporation counsel, but what I would prefer to see is a solid set of board rules that define what good conduct, good behavior is, define misconduct, and say if you violate these, then we are going to move and penalize you in the following way. And that's all within your board rules. That's what I'd like to see. Again, this is providing some sort of framework to evaluate whether penalties ought to be imposed for release of privileged or confidential information. So when we talk about this as well, we get into this whole reputational discussion. And what I mean by that is that it's bad for your reputation if you get involved in ethics concerns. It's bad for your reputation if you get involved in conflict of interest issues. It's bad for your reputation if you start disclosing information that's contained in closed session. But even more importantly, in my mind, is it reduces the public's faith in our system. The public relies upon us to do very important things. And so we rely on the public to have faith in what we're doing so that we can operate as a county. Whenever we start discussing stuff out of closed session, that is not only going to harm reputations, potentially give rise to an ethics or misconduct issue, but it's also going to reduce the public's view of the work that we're doing, such that the public lacks faith or trust in us to do our jobs. So we need to avoid that. There are some additional legal concerns that arise through divulging confidential information that's discussed in closed session. We have potential privacy interests at play. We have other people's reputations that we are attempting to protect by being in closed session. And so we may have legal consequences for disclosing this as well. But I think, again, that the reputational interest and the public trust issue are two very, very important points here that I want to make sure everybody understands and appreciates. I'm going to talk a little bit about the F word, felony, because we've talked about categories of prohibited conduct under 19.59. We've talked about the local ethics code that you have the ability to adopt. We've talked about the doctrine of incompatibility, and we've talked a little bit about privileged information in closed session. But there is a category of conduct under conflicts of interest that is considered felonious or felony conduct, 946.13 of the statutes. And there are two categories of conduct here. Under 946.13, 1A, we've got the statutory prohibition. And when we break it down into the elements of the crime, it means that a public officer or employee negotiated, bid for, or entered into a contract in a private capacity, meaning that that public officer or employee also has some sort of business interest outside of his or her work with the county. So let's imagine that a county board supervisor owns a business, and that business is cutting grass. It's a landscaping business. So 946.13 1A is implicated if county board member, as the owner of the landscaping business, starts entering into a contract with the county to take care of landscaping around the courthouse. Third element, defendant, public official had a private pecuniary interest in the contract, and the defendant was authorized or required by law to participate in the making of the contract in his capacity as a public officer or employee. In other words, there is an oversight function that that particular public official exercises as a matter of holding that office. As a matter of law, there is some oversight there. All right. So those are the four elements of the 1A violation. But then we've got 946.13 1B, and that's a wholly distinct section of the statute with a distinct category of prohibited conduct. Here we've got public officer or employee participated in the making of the contract as a public officer or employee, or in their capacity as a public officer or employee, performed a function requiring the exercise of discretion in regard to the contract, and that official had a private pecuniary interest in the contract. Remember early on, too, when I was talking about 19.59 and conflicts of interest under 946.13, we're dealing with financial issues, pecuniary interest in the contract on 1B. Under 1A, pecuniary interest, all right? So again, we're talking about a monetary interest at stake here. All right, these are really, really significant consequences if you violate 946.13. It's a Class I felony, and the contract is void. All right, it's gone. So you go to jail and you don't get to keep any of the money. So the consequences for violation of 946.13 are very severe. So what do we do to make sure that we don't violate 946.13? You can abstain from voting. You can recuse yourself from deliberations. You can delegate or get rid of any sort of official function having to do with the contract. And then you might be in the clear for a violation under 946.13 sub 1 sub B. All right. Remember, there are two categories of conduct. 946.13 sub 1 sub B deals with the act of negotiating, bid for, contracting, and so on. So it's a very, very active involvement here by the public officer or employee. So if you essentially absent yourself from any involvement in that entire active process, the Attorney General has suggested that you can avoid liability. But, and this is a very big but, if we're talking about a 1A violation, it only requires the authority to act, not the actual action itself. If we remember 1A, we go all the way back here to the prohibition. Look at the last bullet point. The defendant was authorized or required by law to participate in the making of the contract in his or her capacity as a public officer or employee. So having the mere authority to engage in some sort of oversight activities as it relates to that contract may lead to a 1A violation. And so you cannot recuse yourself. You cannot abstain from voting in order to get out of a 1B violation, all right? And what's important here is that this is a strict liability statute. It doesn't matter whether you intended to violate the law or not. That doesn't matter. All the prosecutor has to show is satisfaction of the elements in 946.13, and liability is automatic. So it's pretty harsh. It's pretty severe. So now we've gotten down to the last 7 or 8 minutes, and there are probably other topics here that I could talk about, but I'm going to pause and see what we've got for questions or comments from others. I think that we've answered much of what was asked previously, but what kind of comments or questions do you have about this? Because I know that this is an issue, again, had several conversations with counties around the state about this over the last 6 to 8 months, and I know that we'll probably continue talking about it for some time as we try to get our arms around some of the definitional challenges that we have, and as well trying to adequately define the process by which we adjudicate, if you will, certain alleged violations under conflict of interest or ethics codes. I'm looking over at Sarah because I know she's on mute, but I see nothing here so far.
Got something.
Oh, we just got something. Sarah just told me we got something. All right. A highway foreman owns his own gravel company and is granted a contract for crushed gravel. The highway commissioner works for the company when not working for the county. This is a conflict, correct? Great question, Kim. There are a lot of red flags within those two sentences. That would cause me to want to investigate this situation further. I'm not going to say flat out that it's a conflict of interest under 946.13, but I have significant concerns about this particular relationship. And I'm not going to say what county Kim is from. I know where she's from, but I'm going to say it's a particular challenge in smaller counties, the more rural counties, when we have application 19.59 or 946.13, because there just aren't a lot of commercial alternatives out there. Who knows how many gravel companies are within that county? Who knows how many different people are going to be in the landscape business that can take care of the courthouse? Who knows how many people will be out there willing to shovel the walk outside the courthouse in the wintertime? Problem is, we just got a limited pool of people who are able to do that. And we've also got a lot of people on the county board that have some sort of relationship with that limited pool. So if we eliminate that limited pool, what are we left with? And that's a challenge. And so I would say, Kim, that yes, we've got significant concerns under 19.59 and 946.13, given those two statements that you've made that warrants further investigation. All right. Other questions? What if an employee of the county has a business that competes with a county service? That's a good question. That doesn't in and of itself rise to the level of an ethics issue or a 946.13 issue unless we have an issue that proceeds before the county board. For example, if it competes with county business and the issue before the county board is eliminating that particular county service, well, then that supervisor might have a conflict or ethics concern because any sort of action on the part of that supervisor could produce a benefit to the supervisor's business. So we might have that issue, but in and of itself, that doesn't rise to the level of conflict of interest or ethics issue. But I will say this is that when sitting on the county board, there is a duty of loyalty that a supervisor owes to the county. In other words, that supervisor has to make decisions in the best interest of the county. And so through the process of disclosure, I would hope that that particular supervisor makes it clear and transparent to everybody what his or her interests are, such that there is no doubt that that supervisor is acting with the county's best interests on any official action taken. So that was a very long-winded way of saying that's not an immediate concern under ethics or conflicts of interest, but it certainly, again, raises some red flags. All right, let's see if we have anything else here. I'm not seeing anything. All right, so let me wrap this up by saying this, is that there are a lot of complicating factors in an ethics or conflict of interest analysis. I think back to some of the written opinions that Corporation Counsel has asked me to provide over the years as it relates to application in 1959 or 946.13. And sometimes those opinions are 4 or 5 pages long, single spaced, because they're heavily dependent upon the particular facts of a situation. Then applying some of the legal concepts to those facts can be challenging because of the lack of definitional clarity within the statutes. All of this is to say is that please have a conversation with Corporation Counsel. And if you think it'd be helpful for, say, every 2 years and even numbered years in the spring to have a level set discussion with your county board about what is or is not an ethics or conflict of interest situation. I know WCA has plenty of resources and would be happy to help out with that to the extent your Corporation Counsel doesn't drive that discussion. But again, I hope your one big takeaway from today is that if the answer is yes on any of the 6 smell test questions, you immediately have a conversation with Corporation Counsel to help navigate through that particular situation. So I'm sure we'll be having additional conversations like this in the future, and I'm going to go on mute here so Sarah can actually close this out.
All right. Thank you, Andy. That was great. I'll tell you, my head is spinning right now. I don't know if it's because of all of the information or because I just listened to you talk in stereo because I heard the echo from the room and through my AirPods for the last 55 minutes or so. So it's interesting listening to everything twice. But again, thank you so much, Andy, for this great information. We hope to see everybody back on July 23rd, which is when we will hold our next In the Boardroom, where we will talk about boards of adjustments and the procedures and issues surrounding the role and functions of that you have as a county board member serving on a board of adjustment. Again, another great topic that we've had lots of questions on over the years. So we look forward to seeing everybody back on July 23rd. And again, as one final reminder, you will find the recording from today's presentation along with the PowerPoint slides on our website, wicounties.org. Thank you so much, and we'll see you next month.